Okay, I think we have a quorum here. We're going to go ahead and get started. First, I want to welcome everybody and thank you for attending the webinar today. I'm John Spillman. I'm a corporate and transactional partner at Smith, Gambrell, and Russell. And I'm joined by my partner, Steve O'Day. Steve is a litigation partner who's been litigating for 40 years, including a lot of litigation in administrative actions for federal agencies, which is going to be one of our topics today. Smith Gambrell, for those of you who are not familiar with us, we're a full service business law firm. We have offices in Atlanta, New York, Washington, Jacksonville, Miami, LA, London, and Munich. If I'm not leaving any out. And we are privileged today to be joined by Justin Elangian and Chris Williamson of Aprio. Chris is a senior manager in the Transaction Advisory Services Group at Aprio, and when he's not helping clients with PPP issues, he advises private equity and strategic clients in domestic and international merger, acquisition, and divestiture transactions. Justin's a partner in Aprio's assurance practice, and his clients include operating real estate entities, real estate funds, debt funds, government-regulated entities, nonprofit organizations, and educational institutions. For the past 8 months, Chris and Justin have been leading Aprio's PPP loan forgiveness team and have been advising and educating borrowers and financial institutions on the ever-changing strategies and regulations surrounding PPP loan forgiveness, including some of the topics we're going to talk about today, including eligibility, changes of ownership, and now the recently proposed loan necessity questionnaire. Justin, you want to tell us a bit about Aprio?
Sure, thanks, John and Steve and everybody at SGR here. As John mentioned, my name is Justin Elangian, and Chris and I together with a few others certainly co-lead our PPP loan forgiveness team here at Aprio. And Aprio, for those of you who are not familiar with our name, with our firm, we are a CPA-led business advisory firm headquartered in Atlanta, Georgia, but certainly have offices up and down the East Coast. We're comprised of approximately 600 or so team members and serving clients in across the country, frankly, in every state across the United States and 40 countries around the world. That all being said, we're here today to talk about PPP and really use our expertise and experience in working with hundreds of borrowers across the country and lenders as well, right? Large financial institutions that are doing the PPP loan. So we're going to bring kind of that insight to you throughout today's presentation.
And just to talk about what our agenda is today and what we're going to talk about, the topic mostly today is the process for the PPP loan forgiveness as it works through the lenders and the SBA, and timing, process, some of the specific issues that are expected to be contentious, many of which involve loans over $2 million, which, as many of you may know, are subject, or the SBA has subjected to a mandatory review process by SBA, including review of eligibility for the loan in the first place. And then we'll talk a little bit about avenues for appealing any denial of an SBA determination that all or part of the loan is not forgivable, or a determination that a borrower was not eligible for a loan in the first place. A little bit about what we're not going to talk about today. We are not going to be getting, in this webinar, into the nuts and bolts issues of what expenses are and are not forgivable, how to calculate covered periods, and a lot of the questions that have come up and have been difficult for borrowers and their advisors in putting together their forgiveness application. That has been very well covered by APRIO, among others. APRIO, for those of you coming from our platform and who are not signed up for APRIO's PPP updates and webinars, I strongly urge you to do that. They have done as good a job, if not better, than anybody in the country in keeping up with the very rapidly evolving guidance in the PPP area. But today we're going to be focusing on the bigger picture issues of the forgiveness process, and in particular, some of the issues that will be affecting borrowers with loans over $2 million. And with that, Justin, you want to kick it off with some of the timing and initial process?
Sure. Thanks, John. Just a quick recap. As John mentioned, we're not going to get into the details of covered costs, covered periods, things of that nature. We're going to talk now more so about timing, right? Most of you have had your covered period already end. If you're on this webinar, you're either planning to apply, maybe already applied, and this new necessity questionnaire came out, and now you want to check back in and see what that may mean. So let's talk a little bit about what the timing of PPP loan forgiveness looks like. When does repayment begin? When do you have to apply for forgiveness? This is an area that we see is very commonly misunderstood. So let's start with just timing of application. A borrower can apply for loan forgiveness anytime on or before the maturity date of their loan, including before the end of the covered period. So for clarity here, maturity date. If your loan was approved by the SBA prior to June the 5th, it's 2 years from the date that you obtained your PPP note. And further, if the SBA approves your loan on or after June the 5th, it's 5 years from the date that you obtained your PPP note. So a lot of the questions that we hear from individuals or companies that are working through this process are getting nervous, they're getting antsy about applying for forgiveness because they think they're going to run out of time. Hopefully I just proved to you that that is simply just not the case. Now, from the time a complete loan forgiveness application is submitted to the lender, yes, that does mean you apply to your lender. The lender has up to 60 days to complete their review. But I did emphasize the word complete, and I did so intentionally because rejection rates across the country are approximately 90%. And rejection doesn't mean necessarily that a loan is not being forgiven. It means that when a borrower first goes to apply, they provided incomplete, inaccurate, or otherwise insufficient documentation, and the lender sends it right back to the borrower. And we're not talking rejection just once, but half of the time, it's causing rejections 3, 4, 5, or more times. So when you think about that, if you're really working to expedite your process, think about gathering your documentation before you apply, because that 60-day clock resets every single time it is resubmitted back to the lender. Now, that being said, after the lender does complete their review, they're going to make a recommendation on forgiveness to the SBA. And that's for all loans, not just $2 million and larger. That's all loans do go to the SBA for final approval. The SBA then has up to 90 days to complete their review and remit the appropriate amount of forgiveness funds back to the PPP lender, and then ultimately settle the promissory note between the lender and the borrower. It's worth noting that there is this repayment period, right? It is a promissory note at the end of the day. And so repayment, and this is an item that's changed over time, currently for all PPP loans, regardless of when they were funded, is deferred to the earlier of either 10 months from the end of the covered period. So yes, that could be 24 weeks, that's your covered period, and then 10 months from that point forward before you are contractually obligated to make your first payment. However, if you did apply for forgiveness, and let's say you received forgiveness in part or were otherwise deemed ineligible, then payments would begin that next month. One of the hot topics here, as we think about deemed ineligible, I've already kind of alluded to this necessity questionnaire, is what we're seeing cause a significant amount of concern for many borrowers. And so we want to kind of spend some time talking through this John, I know there's some other items we want to address here as well before we get into the details of the form, but let's start with, items that could potentially cause ineligibility and things that are now being additionally reviewed in further detail by the SBA, in particular, when we think about this particular certification. All borrowers, regardless of the size of the loan, had to make this good faith certification. It was a requirement. And what it said was that current economic uncertainty makes the loan necessary to support the ongoing operations. Not a lot of clarity provided there, right? That could mean a lot of things. If you think back when you apply for your PPP loan, maybe that was April, perhaps going into May, there was a lot of unknowns. And so economic uncertainty was high for substantially any type of business. The SBA didn't provide a lot of additional context here. As you can see, for the guidance that they've kind of expanded on that, I think that the important thing to note had to do with looking into other sources of liquidity. And what it specifically mentions was that accessing other sources of liquidity would otherwise be detrimental to the business. Right? That was part of the support, part of the analysis that a borrower should have been doing. It is worth noting that the SBA subsequently to this came out and said that there is a presumed limited access to other capital, presumed need for loans under $2 million. But it's this certification that was made by the borrower at the time of submitting their loan application, again, on the front end of the process, that is now being kind of further scrutinized for loans $2 million or greater, or those that have affiliates whose aggregated loans together are $2 million or greater. That is giving rise to this loan necessity questionnaire that we're going to get into some details on in the subsequent slides.
And Justin, I think one point to be clear on is that if a borrower's forgiveness application determines that a part of the loan is not forgiven, but that the borrower is eligible, then you repay the loan on the term of the loan. If the SBA determines that a borrower was ineligible, and again, they've made it more or less clear that they're going to be looking at that primarily on loans for $2 million and up, then the loan will be repayable immediately after that determination unless it's appealed. So it doesn't just become a term loan if you were determined to be ineligible. And the certification, you're correct. That guidance has evolved, but it hasn't evolved in much detail as to what that really meant. And we'll talk about some more of those topics as you go on.
Yeah, John, that's right. And I'll tell you from the work that we're doing from the lender side of the equation, as John mentioned, if they were deemed ineligible, technically what that does require repayment to occur. Certainly, I'll tell you, lenders are working with their borrowers through that process, right? They have an inherent interest in making sure that the borrower does have the ability to pay. Certainly, as you think about that from the perspective of those that are, if we're dealing with those that are responding to the questionnaire, right? Those are loans together with their affiliates, $2 million or greater. For a lot of banks, those are really valuable customers. And keeping in mind, the PPP loan is non-recourse. So you've got an unsecured loan to be repaid, and if we're talking a $5 million loan, the lender wants to work with that borrower to figure out how to work through that process. And so they may refinance it, they may amend the note. But John, you're certainly correct. Based on the way the terms are written, that's not a requirement of the lender. That's a negotiation that would need to take place. Now, as we get into the details here a little bit on the questionnaire, I think that's probably what a lot of people are interested in and wanting to know more about. Where does it stand? What does it mean? What are the big questions that we're seeing cause some concern, or at least raising some eyebrows? The loan necessity questionnaire is referred to as one of two. There are two of them depending on the type of the business, right, for profit or non. It's the form 3509 or the form 3510. Again, depending on if it's a for-profit entity or a non-profit entity, but the contents of which are substantially the same. I saw a question already come up about filing the form. Who must file these? A borrower who together with their affiliates received a loan of $2 million or more. And yes, if let's say you had multiple affiliates and then the aggregation of those together is over 2 million, that questionnaire would be completed for each of the associated borrowing entities. Now, from a timing standpoint, where do we sit with this form today? What does it mean? The form was put forth by the SBA on October the 26th, and it was subject to a 30-day comment period. So we're currently still sitting within that. We've got 5 more days. Fortunately, they decided to conclude the day before Thanksgiving. But the proposed form, albeit using that term proposed, doesn't mean that it's not live, that it's not active. I can assure you, in the lenders that we're speaking to, this form has been put from the SBA to the lender to ultimately be completed by the borrower. So we're going to talk about that part of the process here. The way that it works tactically is that the borrower submits their loan forgiveness application to the lender does their review, goes to the SBA. When the SBA is going through their review process, there's going to be this trigger that says, hey, we need that loan necessity questionnaire to be completed. And so what happens at that point is that the SBA then puts the questionnaire request to the lender via the SBA portal. The lender then has 5 days to take that request and get it to the associated borrower. The borrower in turn will have 10 days to respond and complete their questionnaire with the associated documentation provided back to the lender. The lender then has 5 more days to get it back to the SBA. And that entire process is part of that 90-day SBA review window. So the reason it's really important to talk about it now, even if for those of you in the audience who have not yet received the form via your lender, maybe you haven't applied yet, maybe you don't know why the lender hasn't given it to you, is preparation, because you have a short period of time. And that's what a lot of this conversation we're going to have here today is how to be proactive with your process. Build your advisor team, understand the information you're putting together, understand how you want to respond to certain questions. And then ultimately, in the unfortunate event that you're deemed ineligible, what does it look like? What are your options? And Steve's going to help us talk through that as we get into the conversation. I'll tell you that lenders are evaluating this on a go-forward basis on how they are going to handle this questionnaire. Are they going to put it forth prior to being required by the SBA? It's being discussed. It's going to vary lender to lender, as that's who's really facilitating the front end of this program as the engagement directly with the borrower. Currently, and as of some trade organization calls that we sat on just yesterday, borrowers are not receiving this form from lenders because lenders aren't giving it to the borrowers unless the SBA is specifically requiring it. That's really happening for 2 reasons. One, it's still in its proposed state, right? This may not be the final form as we see it. Certainly those that are following April, you get our email communications. We had a communication go out yesterday because the AICPA, backed by 80 national organizations, have now formally pushed back to Congress, to the SBA, to the Treasury, kind of disputing the need for this form. And we're going to understand a little bit more as to why as we get into specific questions. But included as part of those 80 national organizations aren't just those that are representing the borrowers, that are advising the borrowers. These are organizations that have thousands of PPP lenders encompassed within their membership. And so there's a lot of support and pushback on this. And I think that's probably a pretty good segue here to get into what are some of those key questions that we're seeing on the forum. Why is this so concerning? Why is there so much resistance from both lenders and borrowers alike? Chris, I think this is probably a good time to start talking about some of the things we're seeing, some of the concerns that we're hearing from clients. Starting with the first item here, and again, noting that this is not all of the questions, these are the highlights that we're seeing, and those are the ones that we're going to go through. But let's start, Chris, with gross revenue and what we saw about this request about Q2 of 2020. Can you give us some kind of context and feedback of what you're hearing?
Yeah, I mean, I think the overall feedback on this questionnaire as a whole, and especially on a point such as a period over period comparison, is what does performance, gross revenue, for example, in Q2 have to do with loan necessity? Meaning, every business was impacted differently by COVID. And the PPP program came out and began lending starting in April. And as you're looking at your uncertainty in April, already in the beginning of Q2, there's a very different lens or a very different probably view of what 2020 is going to look like than maybe there is now, depending on how your business ended up performing. So I think what we're hearing the most from our clients is that, there might be, depending on the business, there might be a lag in performance. There, an accounting firm, for example, might be a laggard in certain ways in terms of cash flows, in the sense that Q2 might have performed better than expected, but then Q3 might have been a completely different story. And unfortunately, the questionnaire doesn't ask for Q3, it asks for Q2. So a lot of questions we're receiving from clients is, what do I do if Q2 is strong, but Q3 is really where I saw the hit? Can I write in certain impacts beyond Q2? I think you could formulate a large number of questions based on these responses here. And really what we've been going back to in all of this is that this questionnaire is an information gathering activity to help the SBA facilitate their review process and to help them narrow down certain risk levels and help them narrow down those that they might dig into a little bit deeper. They've already put out that they're going to review every loan in excess of $2 million. I don't remember the exact count of how many that was, but there's a large number of those. So we kind of expected from a pure capacity perspective and ability to review that there would be something coming that would help them narrow down that process. And so I think the most important thing here is, if your Q2 revenue, for example, wasn't down compared to 2019, does that mean you're ineligible? I think the answer is a strong no. I think it is a factor that will be considered, but certainly not the only factor. And not to go down this list in full, but I think similar to that for the other projects, for the other points here, there's a case to be made for all of these, why any such item might look negative at the face of it in terms of just filling out a questionnaire, but there might be much bigger story behind it. So we're trying to not cause too much concern here because of the amount of unknown. I mean, we haven't seen the SBA use this in any specific sense of actually determining eligibility at this point. I think it's an early process, as Justin mentioned, with the comment period still open, potential for changes. But generally understand the cause for concern, and that's what we're seeing across our borrowers is a lot of concern because not every borrower fits in the same scenario that you can just use a blanket period compared to a different period and get to a conclusion that determines whether you're eligible or not. I'm interested, Justin or John, there's a question in the Q&A that I think sits in this slide, and we can answer it now or in a few minutes on credit elsewhere. I do agree that it was expressly waived as part of the PPP program, that the ability to obtain credit elsewhere was not a consideration. When we look at this questionnaire, I don't know that it really directly has a point that says, you sought credit elsewhere and were unable to get it. So I'm not sure that it contradicts that point in the program. But I do think, given the questions on cash and distributions of revenue, it sort of leans towards that direction and causes a little bit of concern. Do any of you have any comments on that question?
I do think that's relevant, Chris. And again, just to be clear, there is nothing in the CARES Act, in the statute that created PPP, or in the actual regulations to suggest that a PPP loan would be denied eligibility or forgiveness in hindsight based on unanticipated strong performance after the PPP loan was received. That is not the law, and one of the questions has been about the credit elsewhere, which is a normal SBA requirement for normal SBA loans that says you can only get an SBA loan if you can't get a loan elsewhere. And so that the fact that was waived in the statute suggested that the subjective determination of the necessity by the borrower's own view of how necessary the funds were. And again, in the context of the purpose of the act, that was to avoid preemptive layoffs during a time which was anticipated to be a couple of months where everything was shut down and would then open back up. So the bigger picture concern on the questionnaire, and a lot of borrowers and reflected in our questions, is whether the SBA can go back and effectively rewrite the act and look at your performance after the fact and use that as a basis to deny eligibility or forgiveness. And probably the answer to that is no. There's no clear indication that's their intent, but this questionnaire has suggested the questions that they may be going in that direction. So one of the questioners asked whether the SBA can effectively rewrite the statute, and the answer is no. But one of the, anytime in federal litigation, and Steve will talk about this in appeals, there is a question of how far an administrative agency can go in interpreting statutory language, and I'm sure that'll be an issue in some of these appeals.
Yeah, John, I think something you mentioned there is an important point. This is a questionnaire, and I think it's important to keep in mind there's no indication yet from the SBA on how they're going to use this information. We know it's somehow, in some way, shape, or form, getting back to the concept of necessity, right? Because it's called the loan necessity questionnaire. But we don't know that, depending on how these questions are answered, how that's going to impact the SBA's independent determination. We don't know things of, did you answer 6 questions the wrong way? There's nothing that says what that looks like and how that's going to trigger the SBA review. And so right now, it's a really important time to be working with whoever you are using as your advisor throughout this process to understand how you're going to do some positioning. How could this be perceived? How to be prepared. Again, I'm going to keep saying this over and over again as we go throughout this presentation, because it really is that important. Steve's going to touch on some of this more as we go about thinking about the information you're putting forth when you do your completion of this information. And so it's not I'll deal with that after the fact. It's bringing those individuals into your ecosystem right now, if you haven't already done so. Now, some of the other questions, again, we're not going to go through these one by one, but as you see some of these items, the big point of this, which is really, I think, what's been concerning for many borrowers, is that all of these questions, as you're looking at just the big ones that we have here on the screen, all happened after you received your PPP loan. Whether that's talking about Q2 gross revenue, capital improvement projects, distributions, that certainly caused concern for several. Maybe prepaid debt. I think that was probably something hopefully you weren't doing anyway. I think the optics on that right off the get-go would not have been favorable. But then we get into salary limits. And again, not saying you could not have compensated, but we didn't know. And now you have to report it, right? For both owners and employees. And so these are all things that you really need to be thinking about and understanding, how could this be perceived? We don't know how the SBA is going to use this data, but I think there's some indication here of saying, if you had the ability to pay distributions, if you had the ability to make capital improvements, if you had the ability to continue to compensate employees or owners in excess of an annualized rate of $250,000, why didn't you start working down those measures first before you said you needed the PPP loan? Again, no necessarily direct correlation between an answering of this question and where the SBA will come into play, but those are certainly the things we want to be thinking about. I think certainly one of the aspects that I can say I enjoy about this is this concept of professional skepticism. That's what we bring into our audit practice. And I think that's something we're thinking about here. Think about what could happen. Think about worst case scenarios. You want to be prepared for what could be, even if that's not what happens. Be conservative. Of course, it's going to be based on the risk tolerance level of each individual borrower as you go through this process. So there's certainly not a one-size-fits-all answer as you look at these items. Now, that kind of is a really good way to kind of drive us right into this, the questions that we still have, particularly related to the questionnaire in and of itself. I think, as I was just speaking to here, there's all this data that the SBA is requesting, a lot of that is after you received your PPP loan. A lot of those, the starting point for many of those questions is March 13th. And you'll see that over and over again in the questionnaire between March 13th and the end of the covered period. That's that for most of those questions, that's the period of time that a borrower would be looking at, evaluating, and responding to. There's, I mentioned the comment period. I mentioned this letter that the AICPA sent, again on behalf of many other organizations as well. And knowing that it's still in the comment period, could the questions change? Could questions be removed? Could questions be added? I think those are all things to continue to consider. Again, we have 5 more days till the comment period ends. It does end on November the 25th. We'll see how quickly that the SBA acts and perhaps updating if they decide to make any modifications to the questionnaire, because there's no certainty on that either. One of the things in the lenders that we're working with is when they're looking at the timing, the lender review process. I mentioned that they have 60 days to complete their review from the complete loan forgiveness application. The question now arisen is, at what point, if ever, does this questionnaire become part of that process? Does that be part of the trigger of a complete loan forgiveness application being submitted? That's to be determined. Something we simply just don't know at this particular point in time. I think hopefully, certainly from a lender perspective, I saw a question come up about what does the lender need to do? The lender in this part of the process, again, the form comes, or the request for the form comes from the SBA via the SBA portal. It goes to the lender. Then it goes to the borrower for completion. What is certainly concerning for many lenders out there, we're hearing a ton of pushback from the banking industry on this aspect, is once the borrower submits it back to the lender actually has to manually enter in responses to all of the questions asked into the SBA portal to get it back to the SBA, and then they pass along the associated documents. There are something like 79 different questions, depending on how they get answered. There can be a part A, a part B, a part C. If you think about that, and knowing that lenders have 10 logins to use the SBA portal, and you think of the volume of loans that could be, not to mention the potential for manual error in the inputs, that obviously is concerning, especially when you take into consideration that a lender has no responsibility to review, provide any insight, interpretation, or recommendation regarding forgiveness associated with this questionnaire. They are simply facilitating the process between the borrower and the SBA. So from a lender perspective, I can tell you they certainly don't like this whatsoever. And I think I've hit on this already. How will the SBA make an independent evaluation of need, right? We know that they're going to ask certain questions. They want certain information. How that's going to be applied, how that's going to be interpreted, we simply just don't know yet. And I think what we're seeing from a lot of borrowers that are going to be required to submit this form is, I don't want to be the first one. I think that certainly depends on what the results of those questions yields, right? If I'm a PPP borrower and my loan's over $2 million, I'm going to get all the way to forgiveness, and I look at those questions and say, my Q2 revenue in 2020 as compared to 2019 shows that it dropped significantly. I haven't been able to make capital improvements. I haven't made distributions. Maybe I don't have as much concern about need because I look at those questions and say, this is more of a qualifier of need than a disqualifier of need. It can certainly go that way just the same. So it really is important to really think through the process, think about your strategy as you go through that. An item of note relating to this form is it does have the opportunity for all the questions to mark them as confidential. Marking it as confidential does not mean that you don't have to respond or provide the associated information. What it does mean is, as we think about PPP loans and the Freedom of Information Act, right? PPP loans, previously, certain loan data has been provided, and it just sits there on the Treasury's website. And It's been aggregated differently depending on loans $150,000 or below or those more. And the amount of information, I'm sure we all remember when Bruce Chris and Shake Shack and the LA Lakers, for that matter, got PPP loans and they got slammed from a PR perspective. That's how that information can be obtained, because this data is part of the Freedom of Information Act. And that was now, some advancement on that process happened about 2.5 weeks ago, where a federal judge ruled that the SBA needs to provide all loan data for all loans, including precise loan amounts. So when you think about the opportunity to mark something as confidential, I'm almost not sure why you wouldn't do that, but certainly work with your advisors as you think through that process. Now, coming back to this last piece about need, we don't know how the SBA is going to evaluate that. And so certainly they have the ability to determine that you are not eligible to receive a PPP loan or not the amount of forgiveness you are seeking, whether that's related to need or other eligibility criteria. And I know Steve's got a lot of ideas here on what you can do. There's one in particular to focus on and laying out the approach and the tactically on how do you work through that process. So Steve, why don't we kind of transition here into this SBA appeals process and what that looks like?
All right. Good morning, everyone. The reason they save me till last is that hopefully you won't ever have to talk to me because if you've had John and Justin and Chris helping you through this forgiveness process, you will have gotten your loan forgiveness. You go home happy. I come into play if your cart or truck or whatever it is you're driving is already in the ditch. You didn't get your forgiveness, or you didn't get as much of your forgiveness as you would have liked to have gotten. So the statute and the regulations provide a very specific appeal process that is designed for this program, not for anything else. And it reflects the same kind of effort to make everything go quickly that is throughout the PPP process. And so you have very little time to get your act together, appeal it, and hopefully win the appeal. So the first question that comes up is, what can be appealed? Well, so this process, by the way, was adopted in what is called an interim final rule. That means that the agency adopted it without any notice and public comment. It went into effect as soon as it was adopted. So this final rule in the appeal process is in effect. So what can be appealed? What can be appealed under the statute is an SBA loan review decision. And that is defined as an official written decision by the SBA. So you're not appealing the lender's action, you're appealing the SBA's actions after it completes a review of a PPP loan and finds a borrower was, 1, ineligible for a PPP loan, or 2, was ineligible for the loan amount received or used the loan proceeds for unauthorized uses, or 3, is ineligible for loan forgiveness in the amount determined by the lender in its full or partial approval decision issued to the SBA. So, or 4, is ineligible for the loan forgiveness in any amount when the lender has issued a full denial decision to the SBA. So those are the 4 actions that can be reviewed, and they are all actions by the SBA. Now, the SBA can undertake a loan review at any time, but only final SBA loan review decisions can be appealed. A decision by a lender is not appealable, although a borrower can request the SBA to review a lender's decision on the forgiveness application. Now, the appeal by a borrower of the SBA loan review decision does not extend the deferral period of the PPP loan. And here's one question that really raises an issue as to whether you can appeal anything that the SBA does. If the lender makes a decision of a PPP loan forgiveness amount that is less than what you liked, and the SBA remits to the lender the amount that the lender determined, then you cannot, a borrower, according to the regulation, a borrower may not file an appeal and must begin repayment of any remaining balance of its PPP loan that's left over after the partial loan forgiveness. That leaves some issues about due process. You know, you're not happy with that. It's saying you can't appeal it. Maybe you can appeal it under another federal statute called the Administrative Procedure Act because it's a final action by the SBA and you are harmed by it. Maybe you can also argue that it denies due process that you were unable to appeal that decision, but that's what the regulations say. So what is the process for an appeal? If you don't hear anything, if you don't remember anything that I tell you today, please remember this. Your process for an appeal should be starting right now. In other words, you have to put your best foot forward with the lender and the agency, because that is what the decision is going to be rendered on if you have to appeal it. It's called the administrative record, whatever is in the administrative record. So you need to get with your internal folks or your outside advisors, and you need to put together the best package you can, because that is what the administrative judge is going to be looking at in deciding whether or not your appeal is successful. So the process starts now in putting your loan forgiveness application in putting it together and submitting it. So getting back to the process for an appeal, you have 30 days after receipt of the SBA's decision in order to file your appeal. 30 days. That's jurisdictional. If you miss it, your appeal is dead. Once you file the appeal, it'll be assigned to an administrative judge, and that judge is going to issue a notice and order that is going to designate what happens next. Typically, it will say that the SBA has 20 days to file the administrative record, that is what it had in front of it when it made its decision, and has 45 days to file a response to the appeal petition. The judge then will issue his or her opinion within 45 days after the record closes. Either party can then request reconsideration or request for a review by the administrator of the SBA. And in fact, a request for review by the administrator of the SBA is a precondition to being able to appeal the decision of the administrative judge in federal court. So you have to make that request for review by the SBA administrator. So what has to be in an appeal petition? The petition has to include the basis for the Office of Hearing Jurisdiction, including, but not limited to, evidence that the appeal is timely filed. It must include a copy of the SBA loan review decision. It must include a full and specific statement as to why the SBA loan review decision is alleged to be erroneous, together with all factual information and legal argument supporting the allegation. So this process is essentially backwards from the way most litigation occurs. Most litigation occurs with a short and plain statement of your claims, and then you develop the evidence, and then you submit your detailed argument at the end. In this process, you have to have your detailed argument ready to file within that 30-day period. It's got to be included in your petition. This is your chance to make your case, both factually and legally. You also have to include the relief that you are seeking, full forgiveness or whatever it is that you're trying to get. And it has to include signed copies of all payroll tax filings actually reported to the IRS, and state quarterly business and individual employee wage reporting and unemployment insurance tax filings actually filed with the state. It's got to include signed copies of applicable federal tax returns for the relevant period, actually filed with the IRS, documenting income for self-employed individuals or partners and partnerships. The maximum length of the petition is 20 pages. So you have to make your factual argument and legal argument within the 20 pages. That doesn't include the attachments. All those attachments that I just mentioned are in addition to the 20 pages. And you have to serve a copy on the Associate General Counsel for Litigation for the Small Business Administration. Only a borrower on a loan for which the SBA has issued a final loan review decision has standing to appeal. So only the borrower can file the appeal. After the appeal is filed, as I said, the administrative judge will issue a notice and order establishing a deadline for the SBA to produce and file the administrative record, and specifying a date for close of the record. The record's going to close 45 days after the date of the hearing officer's receipt of the appeal, unless additional time is requested and granted by the judge. The administrative record must include the relevant documents that SBA considered in making its final decision. The record need not contain all the documents pertaining to the appellant. So the SBA can leave some documents out based on privilege or its contention that those documents are not relevant, but the appellant can object to a claim of privilege and may also object to the absence of any document from the administrative record. Those must be filed within 10 calendar days of the receipt of the administrative record. Again, everything moving very quickly. The SBA then must file its response to the petition, and no reply to that response is permitted unless the judge directs otherwise. So again, you don't have a right to do anything else after you file your petition other than objecting to things being left out, unless the judge provides that right to you in the process of the appeal. All the appeals, as I said, will be decided solely on a review of the written administrative record, the appeal petition, the response, and any admitted evidence, and an oral hearing if one is held. But the judge may not admit evidence beyond the administrative record. Discovery, as you normally see in litigation, is not permitted unless the judge determines that the SBA, at its request, has made a showing of good cause for discovery. Oral hearings are not going to be held unless it follows a motion of a party, or at the judge's initiative, the judge concludes that there is a genuine dispute of material fact that needs to be addressed in a hearing. So the standard of review is whether, based on the administrative record, the loan review decision was based on a clear error of fact or law, and the appellant has the burden of proof by a preponderance of the evidence to show clear error of fact or law. Now, there was a question earlier about whether the SBA can change the terms of the statute in its regulations and in its guidance documents. There is something that is filed in federal courts called Chevron deference. And the reason it's called Chevron deference is it's named after a Supreme Court case involving Chevron, in which the Supreme Court decided that federal courts must defer to a federal agency's interpretation of its authorizing statute unless that interpretation is unreasonable. So the question is, if they change or contradict clear terms of the statute, then it's going to be reversed. But if it is a reasonable interpretation, then it's not going to be reversed. The federal court will defer to the agency. There are some provisions for what's called an interlocutory appeal. That's an appeal while the case is still pending before the administrative judge. That would be an appeal to the administrator or administrator's designee, but it only addresses certain issues like a claim of privilege or the judge's ruling on a claim of privilege. Alternate dispute resolution is encouraged if the parties can get together either with a mediator or by themselves to resolve a dispute. That is also encouraged, but again, you don't have much time. The final decision will contain findings of fact and conclusions of law, the reasons for the findings, any relief ordered, and it becomes final, a final decision of the SBA 30 calendar days after it is served on the appellant unless a request for review is filed pursuant to the statute or a request for reconsideration. As I said, the request for review by the administrator is a prerequisite to being able to challenge the decision in federal court. The request for review and reconsideration must show an error, must clearly show an error of law or fact that is material to the decision. And it must set forth the party's specific objections to the initial decision and any alleged support for those objections in the record, in case law, et cetera. And again, in order for a borrower to exhaust its administrative remedies and file an appeal in federal court, you must have filed and served this request for review by the administrator. But assuming you did that, you can then go to court to challenge the decision of the administrative judge. And again, the standard of review is clear error of law or fact. Also importantly, a prevailing appellant is not entitled to recover attorney's fees. So that's obviously something you're going to have to take into account in trying to decide whether you should appeal this decision either by the SBA or by the administrative judge and finally the administrator of the SBA. So that is a very quick overview of the appeal process. As I said, hopefully you don't ever get there, but if you do, it will have been very important to have your case having been presented to the SBA already in order to justify your forgiveness application. Thank you.
Steve, I've got a question or two for you, one of which came out of the Q&A. So just in terms of timing, you mentioned the borrower has to file the appeal. Someone had a question on actions, taken in certain time periods. So we're thinking of the questionnaire and compensation, distributions, acquisitions, and all that activity they're asking about in the questionnaire. How about after the point of loan forgiveness decision being made, or after the end of the covered period, or really after all the periods that they're questioning about in the questionnaire? Should the borrowers be concerned that the SBA might reach to kind of get even more future information, meaning, Q4 2020 distributions, if that came after even when the forgiveness decision was made? Should they be concerned that the SBA might come for that too, or is it that you submit what you have and that's all that goes into the appeal process?
Yeah, once the appeal, once a final SBA decision is rendered on the forgiveness application, then that's when the time starts for appeal and everything goes into the jurisdiction of the administrative judge. So at that point, the SBA can no longer make changes unless you have a alternate dispute resolution and reach a settlement with the SBA. That settlement can of course resolve the case, but it goes to the judge. The judge makes the decision based on the record as it was before the SBA when it made its decision. So there's not additional information that it can be requested, with that one exception that the SBA can request the opportunity to pursue discovery, which is things like interrogatories, document requests, depositions, but has to make a showing to the judge that discovery is relevant to the record as it appeared before them. The whole process is designed to, as I said, for speed, to be decided within a very specific period of time. So there are very strict limitations on any additional information. So the short answer, Chris, is there should not be a concern about the SBA going out and getting additional new facts to support its decision. Its decision has to have been proper based on the record. If you can show a clear error based on the record, you should win.
A follow-up to that, Steve, and I saw a question or two come in about some of the documentation requirements. If I'm under $2 million, is there a chance I'd have to fill out the necessity questionnaire? And I gave kind of more of a follow the guidance response. Wanted to know kind of what your take may be. Granted, this is somewhat speculation. The documentation requirements for any loan and any application that's being used about documents that a borrower must maintain effectively says all records relating to PPP, right? From the very beginning all the way through to the very end, whether it has to do with supporting documentation, economic uncertainty and need, compliance with the program, you name it. Let's say that that's not required to be submitted, right? In many cases, a lot of that information, or there's a section on documents a borrower must maintain. And then the noting that the document retention period is 6 years from the date a loan is forgiven or repaid. What if a borrower is sitting in a situation where it's with SBA review and they now start asking for more and more information? Should a borrower start being concerned that the SBA is starting to dig to kind of maybe build some more of that case file, if you will, because then that would be on record at that point in time?
Yeah, everything that the SBA asks for, you have to presume they are asking for it because they don't they can't make a decision of forgiveness based on what they already have. And your response to everything they ask for should be, first and foremost, what supports my application for forgiveness? And so you need to structure how you respond to those requests with, if they request limited information that is not so great for you on whatever the issue is, and you have additional information that they didn't ask for that does support your loan forgiveness application, then you need to submit that additional evidence, because the decision is going to be made, if you have to appeal it, based on what was before the SBA. And if they don't have it and it supports your application, then at that point it's too late. So whatever comes in, whatever questions come in from the SBA, think about, you answer that question, but you also provide information that is supportive of your application if it helps in understanding the information that the SBA asked for. I want to also mention one other thing that Justin mentioned earlier, and that's the confidentiality issue. You can designate portions of your petition, portions of the record as confidential before the administrative judge. And what that means, Justin was right, what that means is that the SBA cannot provide that information in response to a Freedom of Information Act request by the press or your competitor or whoever, a private nonprofit that is interested in these issues. They can't provide it unless somebody goes to court and says, wait a minute, they withheld this information, it's confidential, it's really not, and a judge orders that it be produced. But as Justin said, anything that is important to you as a business to keep confidential from competitors, from the public at large, whoever it is, ought to be designated not only when submitted to the SBA, but also in the appeal process.
Steve, quick question. Is it fair to assume that in light of the streamlined administrative appeals process and the tight timelines, that appealing an adverse determination from the SBA would be less expensive for a borrower than they might traditionally think of regular commercial litigation? Absolutely,
it will be less expensive. Commercial litigation generally lasts, a year or longer, unless you have a rocket docket that you're in front of that the judge is pushing you a lot faster. In commercial litigation, you have discovery, so you have depositions, interrogatories, you hire experts. All of that stuff is not present in this streamlined appeal process. So it would be, hopefully, you have done all the work in submitting the information in support of the forgiveness application and in response to any questions of the SBA. So the appeal process would simply be marshaling all those facts into a persuasive argument using the law that the judge will believe when you say, hey, they did us wrong, you need to correct this. So that, it would definitely be less expensive than normal litigation, and it's so much quicker. I mean, we've been involved in a number of administrative appeals that outlast the time frame that is specified in these regulations because they don't have those time limits. Those kinds of administrative appeals end up being more expensive. this will be a lot of effort in a short period of time, but then it's over unless you have to go to court.
So what are the takeaways? I'm sorry. One of the takeaways then is if a borrower does get an adverse determination, they should at least strongly consider an appeal and talk to their advisors about the possibility of appealing.
Absolutely. What's the potential cost? What's the chance of success? And whether that cost, whether what you might succeed in doing justifies the cost. Those are all questions that can be, you ought to actually be thinking about them right now because it's a very short period of time after the decision comes out. But we're used to dealing with federal administrative appeals in a short period of time. You just have to address it very quickly.
And Justin, just to follow up on a couple of the things you were talking about, I did want to mention very quickly that in addition to the SBA review of eligibility based on the necessity certification that we talked a lot about, there are some other topics that could result in a eligibility, a determination that a borrower was ineligible that is probably going to be coming up in these reviews. One hot topic on the front end was application of affiliation rules. In general, borrowers were limited to 500 employees or less, but that was after that included an entire affiliate group. The rules for determining what that group was were complicated. How they were applied changed a bit in the guidance, and it effectively excluded a lot of private equity owned borrowers unless they had a SBIC lender. And I think it's fair to assume that the mandatory SBA reviews of 2 million and up are going to take a look at that issue if it is an issue in the review. And another is that there were certain categories of borrowers that were simply ineligible for PPP, but that was not in the main PP regs. That was back in the existing SBA regulations. So that was a little obscure and a lot of people overlooked that on the front end. That includes most real estate companies that are just engaged in passive leasing of real estate. It might include companies that do any legal cannabis business or services for cannabis businesses. Come to mind, businesses engaged primarily in lending, and there were a few other categories. But so we may see that eligibility issue come up in several different ways.
Yeah, John, I think that, and we'll kind of take it a little bit to the end here, but some of the things that we see, and certainly what we're talking about here, I want to provide some opportunity to reach out to our team, and I'll kind of forward so you get everybody's contact information here in a moment as well. John, you mentioned eligibility, right? You got ineligible businesses, whether that has to do with an industry or a type of business, whether it's affiliation rules. I saw a question come up about foreign ownership. Certainly all things to be considering, right? They're going to look at eligibility. I think, Steve, we had this conversation. You said they're going to look at eligibility first before they bother going down the path of verifying cost and spend and forgiveness. Were you even eligible to get this loan to begin with? So that's certainly going to be a focal point here. One thing not to overlook is changes of ownership. We didn't get into that here. It's really not designed for particularly this particular forum, but it's worth noting. I know, John, you see it. Chris, I know you see it a ton. We've seen it plenty of times. You continue to see it pick up. There are some very strict rules and processes that must be followed to consummate a change in ownership transaction and not find yourself in default of your PPP note. So I'll make mention of that because that could cause a business to be ineligible when you think about the process as well, even if you were eligible to obtain the loan from the beginning. So a lot of things to consider throughout the process.
And I will note, Justin, that the Aprio team did a good webinar on that very topic, and I assume that archived version of that might be available on your website if people are interested.
That's right. And last item I saw it come up a couple times, brand new information. I'm going to do a quick plug and then John, take us home. So questions come up about the tax implications here. Aprio will be doing a webinar on December the 1st. to go through that. We just got some additional guidance from the IRS 2 days ago to talk about the tax implications associated with your PPP loan and what that may mean, particularly as it relates to expenses and whether or not timing of submitting a loan forgiveness application applies. I'll leave you with a cliffhanger there. Please tune in on December the 1st. Back to you, John, and take us to the end.
We've gotten a few questions about the slides, availability of the slides. I assume we will post links on both of our websites to these slides and if necessary, follow up to the attendees. I think otherwise, we wrap this up and thank everybody for joining. Hope everybody has a safe and happy Thanksgiving this year. Thanks very much.